Public enemy number one, the police whistleblower. If you've been with me all the way along, then you know that I like to warn my listeners that if you have any moral trauma or institutional betrayal because of policing, this episode or this podcast entirely might be too triggering for you to listen. And I do understand if you choose not to listen, but I do ask that you recommend this podcast to someone that you think could benefit from the education I provide within. I left off in episode 5 telling you about how the police service amended their claim against me right before Christmas. So they were already alleging that my public speaking was a violation of my resignation agreement, but this amendment just added on 4 more years of the same thing. So I want to have a discussion now about what it is that they're alleging that I've done wrong, and I want to dive into the truth behind it. I've already mentioned that I'm cognizant of the fact that I should be careful about what I say, because some details are in the public domain, but some are not. So if we go back to 2018, when I first filed my statement of claim against the police service, I was alleging that Chief Brian Larkin had violated a term of my resignation agreement, which required the existence and the terms of the agreement to be held in strict confidence. Now, when they filed their claim against me, they were alleging that I had made complaints against the police service. And in their initial complaint, at paragraph 29 to be exact, because you can look up their complaint on my website, the Waterloo Regional Police Service was claiming that I was violating the full and final release. And the portion they cited in their complaint states that I had released and forever discharged the Regional Municipality of Waterloo Police Services Board, ... from any and all ... complaints, claims which I have ever had by reason of my employment with or the resignation of my employment with the Regional Municipality of Waterloo Police Services Board. Now, I gave you the ... because they had pulled pieces out of the agreement that suited their argument. They were alleging that when I speak publicly, that's the same as if I filed a complaint against them. So to gain a bit more context, I'll now take you to the amendment of my civil claim, and that was filed in January of 2019 because I was also alleging that the Waterloo Regional Police Service violated the same term of my resignation agreement. I was alleging that the appeal they filed of my WSIB claim was a violation of the agreement, and the portion of the agreement that I cited in that statement of claim amendment was the following. The Regional Municipality of Waterloo Police Services Board does hereby release and forever discharge Kelly Donovan from any and all actions, causes of action, complaints, applications, appeals, ... and it goes on. So you can decide on your own, but when I read that, I understand that the term complaints is sandwiched between actions, causes of action, applications, and appeals. It clearly is referring to a legal process. It's not referring to an expression made in the public domain. And as I've said to you, I've made several submissions to the tribunal stating that there is nothing in the agreement that prevents me from making expressions about my experiences working for the Waterloo Regional Police Service. In 2019, the tribunal sent an email to the Waterloo Regional Police Service asking for an unredacted copy of my resignation agreement. Well, they refused to submit it because they said they had all the information they needed in the redacted copy. But it did seem like there was a very small window of time where the tribunal was actually questioning the motive behind the police service's case. When I made my submissions to the tribunal in 2019, I included some of the conversation that happened between my counsel and counsel for the police service during the negotiations of my resignation agreement. It's not lost on me that this communication could be considered privileged under settlement privilege, but in this case, The Waterloo Regional Police Service was directly attacking those conversations. They were alleging that the intent of the agreement was to prevent me from being able to speak freely about my experiences working for them, and that simply wasn't true. In advancing their position that the wording and intent of the resignation agreement prohibited me from making certain expressions, the Police Services Board was relying upon that privileged communication as part of their substantive position taken in their application against me. And despite the submissions I made in May of 2019 to the tribunal, which clearly show that it was not my intention to ever be silenced by the resignation agreement, the police service doubled down and made additional submissions in November of 2019. In those submissions, they admit that they were not alleging that I breached a general non-disclosure clause, but they still believed that my conduct was contrary to the resignation agreement. It didn't seem to matter what information was put before the tribunal because, as I've already told you, it didn't matter how many submissions were made to them. They simply were not willing to hear my request to dismiss the police services case. So here I was now in January of 2023 with this new package of allegations and a new pile of evidence claiming that everything I was doing was violating my resignation agreement. Well, I told you that I filed for judicial review of the most recent tribunal decision. What I didn't mention was part of my application for judicial review was a request for an order in the nature of mandamus, compelling the tribunal to finally address my request to dismiss the police services case. Now, if you went back and read the interim decision of the tribunal from 2019, you'll see that the adjudicator was also upset with the fact that I used the language of the tribunal ignoring my submissions. Well, that's really how I felt at the time. I had made several requests in writing to have the police services case dismissed. I had produced evidence that I believed contributed to my belief that their case was filed against me out of retaliation, and the tribunal was simply not addressing the fact that these submissions had even been made. Did I feel ignored? Absolutely. And I had a right to be heard. So I took this opportunity to explain all of this to divisional court and explain to them that the rules do say that once an applicant makes a request for an order during proceeding, which I did in 2020, they must be heard either in writing or in person. But here we were in 2023, and they still were not willing to hear my request to dismiss the police services case. I had lots of time to get my paperwork together for judicial review, but I only had so many days to respond to the police services request to amend their case against me. So again, this just meant that I had to dig through all of my evidence, put it all back together in a new document opposing the amendment of their original application. As you can imagine, my arguments were largely based on the fact that my original request to dismiss their original case was never being heard, so why would they be given the opportunity now to amend their case? If there were no grounds for their original case, then surely there were no grounds for the amendment. But in the time that I spent in January of 2023 with my laptop in my lap, digging through documents, reading through case law, I stumbled upon a very interesting piece of evidence buried way back in my emails from 2017. Now, full disclosure, as I've said before, my cases are still before the tribunal and before court, and typically somebody like me really should not be speaking publicly about these issues. But I honestly, at this point, am not convinced that I ever will be given my day in court. So although I am going to be careful about the details I release, I do feel it's important that the public understand where we are at today. From the time I resigned in June of 2017 until I filed my lawsuit in May of 2018, I had not disclosed the existence or the terms of my resignation agreement. It wasn't until after the police service filed their case against me in June of 2018 that more details of my resignation agreement were made public. From 2018 until today, there are now 3 published legal decisions from the Ontario Superior Court of Justice, 4 decisions from the Ontario Court of Appeal, and 5 decisions from the Human Rights Tribunal of Ontario. Yet, the police service still suggests that by me speaking about the existence of the agreement today, I am still violating the agreement. And if this wasn't all being done on the public's dime, then maybe this wouldn't be any of your business. Maybe I should wait for the court process to play out. But the reality is that for 5+ years, the police service has been stating repeatedly that I'm violating this agreement. They have stated this to Superior Court and Court of Appeal judges. And this is all based on their belief that when I speak publicly, I am complaining about the police service. So I'm going to give you enough information in this podcast episode to help you understand what really happened in 2017. The intent of my resignation agreement was never to prevent me from speaking about my experiences. The police service are well aware of this fact. I have now put evidence on public record 3 different times to prove the true intent of my resignation agreement. In the fall of 2018, when I filed my anti-SLAPP application in Superior Court, I presented court then with the emails back and forth that show the negotiations that led to the resignation agreement. It was not alleged at that time that these were covered under settlement privilege. And these same emails were presented to the tribunal in May of 2019. The 3rd time was in January of 2023 in my most recent submission to the Human Rights Tribunal. It is my opinion that this evidence completely contradicts the claims made by the police service, but this has not changed the fact that the tribunal has refused to hear my request to dismiss their case. So let's answer this question once and for all. Is Kelly Donovan dishonest? Did she agree in 2017 to keep quiet, but yet has been on a campaign to advocate for whistleblower protection using her experience in policing? Or could it be that the police service has been relying on false statements for over 5 years at a cost to the public of over $600,000 simply to try to silence Kelly Donovan? Let's dig into that. I'm going to reference the submission I made to the Human Rights Tribunal in January of 2023. I'm going to start at paragraph 19 of that submission. And this is where I begin to describe the discussions that happened leading up to my resignation. So on May 1st of 2017 was when I first entered into negotiations with the police service. I received what my lawyer was calling the first offer from the police service. And the first offer contained a confidentiality clause that applied to the settlement as well as my overall ordeal. As my lawyer had put it, no tell-all books. And I would be required to withdraw my HRTO application. I responded to this email within about 20 minutes, and I told my lawyer that I would withdraw my HRTO complaint. However, I would not agree to a general confidentiality clause. So maybe this is a moot point, and I will just let this play out, is what I wrote her. Over the course of the next month, I had continued to make my position extremely clear that I was not going to resign if they were going to restrict my freedom of expression. I knew that as soon as I was not a police officer anymore, the Police Service Act would not apply to me, and there would be no legal reason that they would be permitted to stop me from speaking. I wasn't going to voluntarily give them that luxury after the way they had treated me. So the tribunal had already seen this back and forth communication over the period of a month. Even in the beginning of June of 2017, there were versions of the resignation agreement presented to me that I still did not agree to, because they were always slipping in these little terms about restricting my ability to speak. It wasn't until June 8th, 2017, that we finally agreed to legal terms in the contract. The key piece of evidence that I mentioned at the end of episode 5 was a voicemail message left for me by the police service's lawyer. He had left this voicemail on June 6th of 2017. He really was trying to hammer home an agreement so we could put this issue to bed. It was because of this voicemail where the lawyer is heard saying that the police service is not trying to restrict Constable Donovan from speaking out or saying what she wants, that gave me the assurances I was looking for. It was because of that voicemail that I agreed to resign and agreed to sign the resignation agreement. But again, there is nothing in the resignation agreement that prevents me from speaking about my experiences working for them. And I suppose now this podcast episode will become Exhibit A in their third amendment of their case against me. They have already successfully persecuted me since 2018 on a case that had no merit from the very beginning. So surely by now you understand my desire to share the truth with you. So I do hope by now that you truly understand why I have been so vocal and public about this issue. If I had agreed to sign an agreement that prevented me from speaking, then none of this would have happened. I would not have resigned and been so public about my experience. I would not have advocated for changes to policing laws. So now that you know that I didn't, and now that you know that the police service has proceeded with a case against me regardless, my hope is that you're starting to understand the need for us to be critical of police leadership. We have simply trusted them by default for far too long. And now it's time that we start to trust by verification. And in this podcast series, that's what I endeavor to do, is give you the verification for you to know if you can trust the police service in this case or not. And I'd like to remind you about the mental health warning that I give at the beginning of my episodes, because something like this is enough to trigger a moral injury in a person's brain. We are raised to inherently trust police. We are told to never question police and that police will protect us. But I know that many of my listeners know otherwise. I know that many of my listeners have had negative experiences with police, and some have even lost loved ones at the hands of a police officer. This is the worst form of moral trauma. And like I've said before, it must be treated by a mental health professional. It's not right for police to behave in a way that is so dishonest. But in coming to that realization, it can really call into question all of your fundamental beliefs. So as I said at the beginning of the episode, it's important that you take care of yourself. So I'm hoping that by now you're starting to ask yourself, why doesn't Kelly have more support from the policing community? I mean, from the very beginning, I've always very carefully called out leadership, because most of these decisions are leadership level decisions. I've never been critical of the police officers that are busting their ass on the road, going from call to call to call, doing everything they can to do their job and serve the community. I am critical of those same police officers who choose to not speak up when they see something they believe is wrong. But I also don't blame them for protecting their careers, because I'm a perfect example of what happens to a police officer who speaks up about something they see that they believe is wrong. But at this point in time, in 2023, when the police service is still coming after me, still paying public funds for their lawyer to try to achieve my silence, it's at this point in time that I don't understand why I don't have the support of police officers and police associations. What happened to me could happen to anyone else who decides to open their mouth. Standing by and doing nothing and saying nothing is basically admitting that there are certain individuals who are above the law. But the next few months of my case are going to be very telling. Will the tribunal or divisional court ever open their minds to the idea that they may have been misled along the way? Is it possible that a police service could be proceeding on grounds that they know to be untrue? If you're as curious as I am to know whether or not the police service's conduct will ever be looked at impartially, you can observe my hearing on November 22nd, 2023. If you sign up to my newsletter from my website, policeversuswhistleblower.ca, I'll be sending out information on how to obtain the Zoom details, as it will be a virtual hearing. This case is no longer about whether or not the police service or I have breached the resignation agreement. I really hope you can see by now that this case is about the ability of a public institution to use public funds to silence a whistleblower. We will find out this fall whether the reputation of the police service is so important that divisional court is willing to ignore the facts, or whether the conduct of these public officers can truly be looked at objectively and the law applied. This has become the question that I want answered. The most recent Freedom of Information request I filed was as of March of 2023, and as of that date, the police service had spent $635,000 in these matters alone. If you're wondering if these amounts ever get disclosed to the public through the Police Services Board, the answer is that they do. They're just hidden in the budget. If you look at other fees, typically it will say under there that that includes legal fees. But I'm not sure if it's ever justified to the public why that expense is necessary. And I think now might be an appropriate time to have a general discussion about non-disclosure agreements. The entire issue was really brought to light with the whole Harvey Weinstein case. I strongly suggest watching the movie She Said if you haven't already. It takes you through how the story about Harvey Weinstein actually made it to paper. Allegations had started to surface about Harvey's conduct within the film industry, but nobody had been willing to go on record about what they experienced at the hands of Harvey Weinstein. The story really broke when one courageous female, Zelda Perkins, agreed to go on record despite having signed a non-disclosure agreement. It was because of Zelda's courage that other women stood with her, and together these women brought Harvey Weinstein to justice. I think for the most part, Canadians kind of stood by and watched what happened in the US and probably thought, well, that's happening down there, but that sort of thing would never happen here. But then we started to hear stories about scandals within Hockey Canada. Egregious accusations had been made against players and all but swept under the rug because the lawyers had stepped in and had non-disclosure agreements signed by the victims. This was the first time that Canadians were face to face with the fact that we were no different than the Americans. We had been using these legal agreements to cover up acts that should never be concealed. But the concept of a non-disclosure agreement was not foreign to me. I knew in 2017 that I was not going to resign from my employment and give all of it up if I was going to leave and be bound by an agreement that would prevent me from speaking about my experiences. Now, you can be critical of me if you want. I mean, you can say it was stupid of me to give all of that up just for my ability to speak. But what I had experienced, in my opinion, was so fundamentally wrong that I knew it was only in using my experience that I'd be able to affect positive change. Nobody would believe me if I just left and had a hypothetical story about a police chief coming after an officer for reporting him to the board. I needed people to know that what happened to me was factual, and I wasn't going to let them simply erase any sign of my existence, because I believed then, like I believe now, that if they didn't want people talking about the way they behaved, then they really should have behaved better. And if we actually had true transparency and accountability in policing today, then maybe the leadership would behave better than they do. I was awake to all of these issues in 2017, and my decision to resign did not come easily to me. I was giving up a very lucrative full-time position to start a business on my own, which was full of uncertainty and struggle. But the thing that really helped me make my decision was accepting the fact that I did not share the same morals and values as the police service, and that I would not have any personal fulfillment remaining employed as a police constable for the Waterloo Regional Police Service. I don't think I was experiencing some kind of a midlife crisis, but I do think there comes a time in everyone's life where they do start to question, what is all of this for? And I really knew that this was my chance to leave a legacy. I wanted to set a better example for my kids. I needed them to see that I wasn't going to back down simply because I faced somebody with tremendous power. I knew that what I stood up for in the beginning was right, and it was still the right thing to do to stand up for myself. I had not given anyone permission in 2017 to restrict my freedom of expression, so I didn't understand how, in 2023, their attempts to silence me were still being entertained by the tribunal. Canadians are supposed to be guaranteed freedom of expression. But as I came to learn, if you're going to be critical of the police, that's not always the case. But let me be clear about something. If you haven't already listened to episode 5, I encourage you to go back and listen to the beginning of that episode. That's where I take you back to what started all of this. I wasn't simply some outspoken critic who was criticizing individual police officers or police leaders on my social media pages. I was looking at systematic problems with policing laws, things that were restricting transparency and accountability, because I wanted to improve policing overall for the public and police. And the mere fact that they were trying to silence me from doing just that speaks volumes about where we are with policing today. There was a time that the public were the police and the police were the public, and it was said that police could only govern a society with permission. But we had gone so far away from the principles outlined by Sir Robert Peel. The public had lost trust in police, and police had this us versus them mentality. And anyone who would rightfully criticize actions of police was considered by politicians to be anti-police, which has only solidified this us versus them rhetoric. But despite all of this, and despite the pressure on people like myself to just back down and go away, I do have confidence in myself that what I advocate for are matters of public interest, and that if changes could be made today to improve accountability and transparency in policing, it could one day, once again, be an honorable profession. My ultimate goal with all of this has been to make things better for future generations. There is a push across Canada to ban the use of non-disclosure agreements. There are campaigns such as the Can't Buy My Silence that are actively going from the east to the west coast, getting commitments from organizations to not use NDAs in cases of silencing victims of harassment or discrimination or whistleblowers. It really does sound like a no-brainer to me, because especially somebody who works in the public service, at the moment, we are allowing lawyers that are paid with public dollars to create contracts that will indefinitely silence victims and conceal acts that bring shame to the public service as a whole. If we want public's trust to be restored in the public service and government, we need to start eliminating those who behave egregiously, not the victims who report them. But maybe now you'll understand why I'm still fighting in 2023 to maintain my freedom of expression. I never agreed to let anyone silence me. So I sure as hell am not going to sit back now and watch while it happens against my will at the Human Rights Tribunal of Ontario of all places. Talk about irony. But only time will tell, and that hearing will resume on November 22nd, 2023 at Divisional Court for Judicial Review. Now, in early 2023, I also filed a complaint of duty of fair representation against the Waterloo Regional Police Association. It's really the only thing someone like me can do. An individual police officer cannot file a grievance against the police service. It has to be filed on their behalf by their association. But in my case, my association had repeatedly denied my request for grievance. So the only last step I could take against the association was this complaint of duty of fair representation. That hearing is being held in September and is not open to the public, but I do intend to inform my supporters of the outcome of conciliation. Ultimately, if it is decided that the association does not have a duty to represent me, then the jurisdictional argument will once and for all be put to bed, and I can return to the Superior Court with my allegation of misfeasance in public office. I suppose at this point in time, I'm really just in autopilot, trying to see how far I really have to go to hold the police service accountable. We will also soon find out if it's legal for a police service to restrict constitutional freedom of expression when someone is outspoken about police issues. I hope you'll agree that that's an issue that affects all Canadians. So we've made it all the way to episode 6, and I think I only have one more episode to go. But I do intend to create a second season where I endeavor to further educate the public on these policing matters, not specific to my case alone. Some Canadians do believe that we have whistleblower laws in Canada. I'll be exploring that topic and many others in Season 2. In Episode 7, I'm going to talk more about what it's like to be a self-represented litigant, and part of that discussion is going to be a discussion about the legal profession. So if you've made it this far and I've piqued your curiosity, I hope you'll stay tuned for Episode 7. I was told early on in this journey that this was a marathon and not a sprint. But I do think I can see the finish line in sight, so please stick with me. As always, thanks for listening.